Dear colleagues, I'm pleased to open the third session of this conference on measuring justice. Thank you all for participating online and in person. Many thanks to all my colleagues for the kind words on my work in the field of pursuit of judicial independence. Thanks are due to Karen, the chairperson of the first session this morning, that was very effective and insightful and thought-provoking session. We begin with the presentation of Professor Paul Nemitz on EU Justice Scoreboard as continuation of his presentation in the first session. Professor Paul Nemitz, please.
Efficiency, quality, and independence are the three aims of the annual Justice Scoreboard exercise the European Commission carries out with the member states of the European Union. These three factors are important not only for reasons of the rule of law and bringing it to function through an independent and well-functioning judiciary, but they are also important for economic reasons. Improving efficiency, quality, and independence of national justice systems continues therefore to feature among the priorities of the European semester, the EU's annual cycle of economic policy coordination. The 2021 annual sustainable growth strategy of the European Union, which sets out the economic and employment policy priorities for the EU, reiterates the link between effective justice systems and the business environment in member states. Well-functioning and fully independent justice systems can have a positive impact on investment and therefore contribute to productivity and competitiveness. They are also important for ensuring effective cross-border enforcement of contracts and administrative decisions and dispute resolution, which are essential for the functioning of the single market and any economy. The economic relevance of an independent, well-functioning judiciary has been documented in many different contexts, and in my written contribution I refer to some of those important sources. When we look at the efficiency of the systems, we look basically at three indicators, namely the length of first instance court proceedings, the length of proceedings in all court instances, and the clearance rate. In the broad all cases and in the litigious civil and commercial case categories, the overall number of member states where the clearance rate is more than 100% has increased since 2012. In 2019, the majority of all member states, including most of those facing challenges, reported a high clearance rate, more than 97%, which means that the courts are generally able to deal with the incoming cases in these categories. And there has also been a continuing progress on the backlogs regarding all categories of cases. When we look at the quality of the justice system, we look at four indicators, namely the accessibility of justice for citizens and business, adequate financial and human resources. We need assessment tools be put in place for self-control of the judiciary and self-assessment, but also for assessment by the political authorities and the justice ministries, and we have looked for the first time also more intensely at digitalization. Accessibility issues like court fees and the level of legal aid have an important impact on justice, and our member states have made progress in this area over the last years. But there are also issues such as the court fees, which have remained largely stable, but nevertheless some member states have raised even court fees for low-value claims. The difficulty in benefiting from legal aid combined with high level of court fees in some member states could have a dissuasive effect for people in poverty to access justice. Then, as to the resources, high quality of resources is key for a functioning judiciary, including the necessary investments in physical and technical infrastructure, appropriate initial and continuous training, as well as the diversity among judges, including the gender balance. The 2021 EU Justice Scoreboard shows, in terms of financial resources, the data show that overall in 2019, general government total expenditure on law courts continued to remain stable, with significant differences in actual growth, both in euro per inhabitant as also in relation to percentage per GDP between member states. Almost all member states increased their expenditure per capita in 2019, and a majority also increased their percentage of expenditure related to GDP. As in 2020, the 2021 scoreboard also shows the breakdown of total expenditure into different categories based on data gathered by our statistical office, Eurostat. Women still represent less than 50% of judges at the level of Supreme Courts in most member states. The evolution over a 3-year period from 2018 to 2020 shows that trends diverge between member states, but the proportion of female judges as Supreme Courts has risen since 2010 in most member states. On the training of judges, while almost all member states provide at least some continuous training, few offer training on ICT skills, court management, and judicial ethics, and we consider these areas to be very important. The use of surveys among court users and the legal profession was slightly higher, and now we are in the area of assessment tools, in 2019 than in the preceding years, with a stable number of member states opting not to conduct any surveys. However, there seems to be some variance as to which member states did not conduct surveys, indicating that surveys are sometimes conducted only every second or third year. Accessibility, customer service, court hearing quality, judgments, as well as the overall trust in the justice system remain recurring topics for surveys, but only a few member states inquired about the satisfaction of groups with special needs or about individual awareness of their rights. As to digitalization, the edition of 2021 of the Justice Scoreboard now includes an extended component examining in detail aspects of digitalization of justice. Although most member states already use some kinds of digital solutions, mainly office automation, honestly not a big deal, there is thus scope for improvement. Almost all member states now provide access to some online information about their judicial system. Less than half of the member states have digital-ready produced procedural rules, which allow for use of distance communication and for admissibility of evidence in digital format only. So on the judicial use of digitalization, like the legal profession generally, we are behind, and there is certainly scope for increasing productivity through increased digitalization. Quality, efficiency, and independence. And the scoreboard also looks at the independence as the factual basis for the rule of law report, in particular at the external independence, namely the need that the body concerned, the court, exercises its function, or the individual judge, autonomously without being subject to any hierarchical constraints or subordinated to any other body, and without taking orders or instructions from any source whatsoever, thus being protected against external intervention or pressure liable to impair the independent judgment. And internal independence and impartiality is necessary, namely when an equal distance is maintained from the parties to the proceedings and their respective interests with regard to the subject matter of the proceedings. We differentiate between perceived independence, reflecting input from many different bodies dealing with courts and professional associations, and we look at structural independence. European standards have been developed by the Council of Europe. For example, the 2010 Council of Europe recommendations on judges, independence, efficiency, and responsibility. And we work very closely with the Council of Europe on these issues. The figures provided in the scoreboard do not provide an assessment or present quantitative data on the effectiveness of safeguards regarding to independence. They are not intended to reflect the complexity and details of the procedures and accompanying safeguards. It should also be noted that implementing policies and practice to promote integrity and prevent corruption within the judiciary are essential to guarantee judicial independence. Ultimately, the effective protection of judicial independence also requires a culture of integrity and impartiality shared by magistrates and respected by the wider society. And the recent judgment concerning Romania of 21st of December of the Court of Justice is a warning to all of us that independence can even these days also be put in question by the way higher judges deal with lower courts. And we have seen similar developments also in Poland. So to conclude, the European Union has moved from an economic union to a union of fundamental rights, democracy, and the rule of law. It has developed a variety of legal, political, and economic instruments to ensure that member states comply with these principles laid down in the treaties and the Charter of Fundamental Rights. The annual rule of law reports and the annual judiciary scoreboards by the European Commission and the related political conclusions in the Council and the European Parliament are not only flagships of an emerging common quest of the Union and its member states for highest standards as regards independence, quality, and efficiency of justice. They also demonstrate the importance of democracy and legal systems defending their integrity and good functioning. The Rule of Law Report and the Judiciary Scoreboard, their accompanying measures, the technical support provided, for example, by the Commission, as well as the actions taken on their basis by member states, represent important financial, intellectual, and political investments. These investments are vital in times in which even the highest courts in some countries are being instrumentalized by executives which aim to do away with any type of checks and balances, whether external or internal, whether by courts, by the press, by civil society, or by parliaments. And we have seen some of this in Poland and Hungary, in Europe in particular. And these attacks on judicial independence, on the rule of law, and on democracy require a firm response of all who stand for justice and democracy, whether as individuals or institutions. Thank you very much.
Many thanks, Professor Paul Nemitz, for your presentation. And now it is my pleasure to call upon Professor Diego Garcia Sayan, the Special Rapporteur for the United Nations on the independence of the judiciary and of lawyers. Professor Sayan, please.
Good morning. I am delighted to be here today as a Special Rapporteur of the United Nations, invited to share some views with such a distinguished audience on the main major threats and challenges to independence of justice in the world. Let me express first my thanks for the kind invitation to be with you at this very important conference, and especially my deep appreciation to my friend, Professor Shimon Shetreet, who has performed and continues to perform a crucial role in building a better world based in rule of law and with an independent judiciary. He is having, as we are all perfectly aware, a crucial role in the preparation and guidance of this conference. A special appreciation, Shimon, for the invitation to be with all of you today. In 1994, the United Nations, through the then Human Rights Commission, noting both the increasing frequency of attacks against the independence of judges, lawyers, and court officials, and the link between the weakening of safeguards for the judiciary and lawyers and the gravity and frequency of violations of human rights, decided to appoint a special rapporteur on independence of judges and lawyers. Several rapporteurs have been appointed since then. By decision of the Council, this responsibility has been assigned to me since December 2016. Since then, I have devoted as a special rapporteur to identify and record attacks on the independence of the judiciary, lawyers, and court officials, and as well monitoring the compliance with international standards adopted by the United Nations, such as the UN Basic Principles on the Independence of the Judiciary adopted in 1985. They function as a guiding criterion to assist member states with the standards to guarantee and promote independence of the judiciary. That is, that the courts are accountable to law and free from interference by the executive, legislative branches, or by any de facto powers. I have also come to witness a crucial role that independent judges, courts, and prosecutors play in ensuring that victims of human rights violations obtain effective remedies and protection, and that perpetrators of human rights violations are brought to justice. I have extensively documented in my reports the contemporary challenges that judges, public prosecutors, and lawyers are currently facing around the world. The facts I have verified are leading to follow with concern the increasing authoritarian temptations and ongoing authoritarian political processes in different parts of the world. Distinguished colleagues, in some regions of the world, transitions to democracy have contributed to a significant improvement in conditions for independent justice and the free exercise for the legal professions, the rights of lawyers, and their bar associations. In several countries of Central and Eastern Europe, for example, conditions have evolved positively. The same in some Latin American countries that tend to leave behind obscure epochs of military dictatorships and absolute impunity. In parallel, however, in other countries, democratic rights are in regression and independent justice and the legal profession are under attack. The list is very long, unfortunately. The lack of judicial independence in such context makes it less likely that lawyers will be respected and valued and benefit from the concept of independence, let alone fight to uphold it. It's a Dantesque vicious cycle. Governmental control of the judiciary makes the legal profession less willing to challenge the government or undertake controversial or sensitive cases that may not sit well with a current political institution. Public attacks by political figures against the judiciary, as well as a threat of judicial persecution or intimidation, can further undermine judicial independence, in turn undermining as well the lawyer's ability or willingness to undertake certain cases or represent certain clients. Taking this major context into consideration, I would like to emphasize with you today my concerns on two matters which are having a big impact on independence of justice and which deserve special attention. One is the impact in the justice system from the corrosive effects of organized crime and high levels of corruption and the challenges this is placing on the justice systems. The other is the authoritarian wave covering several countries, including the democratic Europe, affecting judicial independence and specifically the role of lawyers. Dear participants in this conference, corruption has devastating effects on the judicial system as a whole, since it reduces public confidence in the administration of justice when it is perceived corrupt. Simultaneously, however, judges and prosecutors have been entrusted by international law and national regulations precisely with the responsibility of facing corruption so that they can also guarantee the rights of the society as a whole. From that perspective, the UN Convention Against Corruption is a fundamental treaty because judges and prosecutors appear to be the key actors for international cooperation between states against corruption. For instance, Article 11 requires that each state party take sufficient measures to strengthen the integrity of the judicial system and avoid any chance of corruption among its members, without prejudice to its independence. Hence, international cooperation between judges and prosecutors is of paramount importance to effectively face transnational corruption and organized crime. To perform that function, both judges and prosecutors must have the necessary protections recognized in international instruments to ensure their independence and impartiality vis-à-vis any interest that could affect them. In this context, international cooperation attains special attention, vitality, and viability in criminal matters, such, for instance, as extradition or international mutual legal assistance. To achieve such cooperation, independent judicial authorities are absolutely essential. The more independent the judiciary is, the less effective will corrupt practices be utilized by transnational organized crime groups, particularly in their interaction between organized crime members with the private sector or members of the governments in their attempt to influence politicians and the judiciary. Distinguished audience, as you all are perfectly aware, the free exercise of the legal profession and the protection of human rights are closely interconnected. The function of lawyers is not only a basic right for lawyers, but for all the society. It has to do with crucial aspects like access to justice and due process, and further, with separation of powers, checks and balances. This is reflected in at least 4 aspects. First, access to a lawyer, which is an integral component of due process and fair trial. Second, to be effective, legal assistance has to be carried out independently, as is established in the UN Basic Principles and several recommendations in my reports and of my predecessors. Third, the principle of lawyer-client confidentiality. And fourth, free establishment and functioning of independent bar associations. Well, in this context, we have a problem. The world has a problem, which is the authoritarian wave covering several countries, including Europe. Lawyers are today threatened or under attack in Poland and Hungary, Turkey or the Philippines, El Salvador and Zimbabwe, Azerbaijan, or Belarus. The list, unfortunately, is very long. In October 2018, I presented before the General Assembly of the UN my annual report highlighting the essential role that bar associations play in a democratic society and the crucial role the legal profession has to play in upholding rule of law, promoting human rights, and ensuring access to justice, as well as the importance of providing legal education and training to lawyers throughout their career by bar associations. I also gave examples of how bar associations contribute to public discussions on issues such as legal reform, the administration of justice in the promotion and protection of human rights, and the rule of law. In the same report and several statements, I have mentioned severe attacks against bar association as another way to undermine rule of law standards and the activity of independent lawyers. However, despite such a desolated landscape, we have also witnessed various situations which display the leading role of independent lawyers and bar associations to advocate for independent courts, and we have also seen the positive impact of such advocacy. When the justice system has been attacked by political power, in several situations, crucial bar associations in the world have sent their best lawyers to advocate and resist unconstitutional governmental actions. Dear colleagues, distinguished audience, in January next year, or this year, is beginning what will be my last year as special rapporteur. I am preparing my next annual report to be presented to the Human Rights Council on endangered lawyers. I want to express my appreciation to the contributions being received with responses to the questionnaire that has been published and their contribution in regional consultations with organizations and experts working on this area. Several regional meetings are taking place. Very valuable information and views are being received. It is a critical time for all citizens around the world, and especially lawyers, to remain vigilant and protect the independence of the judiciary. The privilege of practicing law carries with it the duty to protect the rule of law, separation of powers, which includes the defense of judicial independence. The judiciary around the world is threatened or under attack. This is a fact we cannot deny, unfortunately. I would like to finish my presentation, dear colleagues, by strongly encouraging the distinguished participants in this international conference to continue joining the efforts of the United Nations and fantastic institutions like the International Association of Judicial Independence and World Peace, or distinguished jurists and leaders and jurists like Shimon, Shetreet, standing up against actions that pose serious internal or external threats against the independence of the judiciary around the world. Quote, protecting judicial independence, as Justice Sandra Day O'Connor said, is not easy. It requires work and diligence and attention. Close the quotation. Defending the judiciary, dear colleagues, is the duty of every lawyer. A strong, impartial, independent judiciary is too valuable to disregard. Thank you very much.
Of working with him and with Eric Helland on the last volume that we just published called Challenged Justice in Pursuit of Judicial Independence. And so this is my opportunity to express to him my deep appreciation and deep gratitude for the fruitful cooperation between Hebrew U and his institution. And I also want to mention that we are planning towards the end of the year, in the fall, a continuation conference in Claremont of this effort. So now I would like to invite Professor Hiram Chodosh. Please.
Good morning, everyone. I'm Hiram Chodosh, and I'm terribly sorry that I couldn't be there with you this week. It's a big disappointment, but I did want to deliver a paper to you pre-recorded. It's December 31st here in Claremont, California, and we look forward to the conference and to this next year. Wish you all very happy, healthy, and fulfilling 2022. The title of this framework paper is Measuring Justice and Judicial Independence, the Impracticable Imperative. My colleague Eric Helland, who will be with you by Zoom, will follow up with his own observations in connection with the observations that I've made here. Thank you very much for listening in. As many of you know, I've spent nearly 3 decades working on the common challenges facing contemporary judicial systems: delay, corruption, interference with judicial independence, as well as under-trial, a serious form of delay in the criminal justice system in far too many countries, and physical and psychological coercion, including torture of the accused. And behind these harsh performance challenges are a wide range of fundamental institutional challenges, some neutral, others pointed: the proper, legitimate place and role of the courts in a democratic constitutional framework, the insufficiency of financial and human resources that courts need to sustain their effective roles, the crippling politicization and societal distrust of all branches of government, including the courts, devastating gaps in civic literacy, weak ethical commitments to rule of law values, and a poor practical understanding of how constitutional systems, including the courts, are designed to function. In this work, I have focused on 2 dimensions of these challenges and their interrelationships. The first is on the theoretical, methodological set of challenges in understanding the comparative nature of the problems and the relative effectiveness of remedies proposed in reform. The second is on the practical set of challenges in working through the policy, political, practical challenges of implementing large-scale judicial reform. This work is informed both by a number of concentrated reflections on methodological difficulties of any exercise of comparison and substantial field experience in a diverse array of national settings, from procedural delay in India to judicial corruption in Indonesia to judicial independence in Iraq. At the risk of reductionism, before I pose a half-dozen questions that help frame the aims of what we call the Measuring Justice Project, I want to share 3 critical challenges of judicial independence with some modestly reconstructive responses for this esteemed group to modify, sharpen, and implement. Challenge 1. Can we see with greater clarity and purpose that the judiciary is the most neglected branch of government? This is pointedly true in a world that has increased its dependency on strong, self-limiting, independent, impartial judicial institutions. We've not invested in judicial institutions in ways that are concomitant to the burdens they've taken on. Since the fall of the Berlin Wall, global commitments to democracy, forms of limited government, the rule of law, the move to private transactions economies, ways to take advantage of the benefits and reduce the harms of globalization, technological transformations beyond our dreams, the advent of universal human rights, and more recently, the rise of authoritarian backlash and political polarization of so many societies. Our judicial systems have suffered from greater burdens and diminished investments. In many places, including in the U.S. criminal justice system, we seem to be living in a Potemkin judicial village in which we rely on the beautiful facade of vital rhetorical commitments, only to find that there's little or less behind the walls to back them up in practice. In my modest experience, our understanding of court performance, especially in the common law systems, is skewed by our fundamental legal training in appellate decision-making. We spend way too little attention on the functional, practical challenges of the courts at the trial, especially pre-trial level, where the thin, burned rubber of the courts first hits the road. In sum, we may be arguably more honest naming this project Measuring Injustice. Challenge 2. Can we think harder about the nature and extent of the problems we're trying to solve? The problems of delay in civil or criminal cases, corruption, torture, judicial dependence are all complex phenomena in their own context, and The oversimplification of them or their remedies makes the words neater on the page, but doesn't advance common objectives in practice. At every stage, we have to think about the why in structural terms and in the context of a specific society with its own contradictions of values, goals, social, economic, political, and cultural conditions and challenges. One threat to judicial independence, for example, is private corruption. We have competing theories for why corruption occurs, political theories, power corrupts, economic theories about the risk of punishment, and cultural or educational theories. For example, the need to distinguish between right and wrong. Each explains, at least in part. None explains on its own. Each and all together provide just hints for reform that's more elusive than effective. This is not only a theoretical challenge, it's empirical. What do we know about the nature of the problem, the extent to which it exists, its impact? Which methodologies or technique can we develop to apply to measuring the problem of judicial dependencies? Challenge 3. Once we understand and can measure the problem, can we dedicate more time to fixing it? Here, for example, what is the role of our Mount Scopus guidelines in effective justice reform? What techniques can we develop to measure their implementation or effectiveness where reinforced? And where, with broader adoption, can they do greater good? To advance our response to these challenges, I'd like to pose a number of questions, a half dozen questions. This is all in the spirit of Nobel laureate physicist of 1946, Izzy Ravi, whose parents were credited by him with his success. When Izzy returned from school to home each day, his parents asked him, "Izzy, did you ask a good question today?" And at the end of the conference, we should ask ourselves, "Shimon, did we ask a good question today?" So here are my 6 questions for the day. Hopefully I'll get one of them right. Question 1. Must we measure justice? Can we measure justice? No, we cannot. It's impossible to do it. We may have no idea how to do it or do it well without assuming too much away. The problems of valuation, comparative measurement are just too complex, vexing, insuperable. And yet, yes, we do it. We measure justice. We do it here. We each have our own views of different legal systems, processes, results, in terms of whether they are just or not, regardless of theoretical clarity or any level of evidentiary accuracy that we may have achieved. We thus measure justice unavoidably, conclusorily, implicitly, even poorly. That may even be true of our assessment of independence. We pick and choose particular features from the mix and may not be able to account for the impact any one has on justice. Does life tenure or other legal protections for judges create independence we want? Is an independent judge more or less impartial? More or less just? We have good reason to say, but we do not have the right theory and empirics to know this is so. Recognizing these challenges, we have to commit ourselves to do it better or at least less poorly. Otherwise, our rhetorical commitments to justice and the indicia of just systems will remain hollow and indemonstrable. Therefore, it may be worthwhile to ask or to even push 2 seemingly incompatible ideas. Measuring justice is impossible and imperative. Recognizing impracticability keeps us humble. Focus on its necessity keeps us committed. We'll come back to that in a moment. Question 2. What is justice? To measure a phenomenon presumes we can define it. The question of justice is large and complex. In Gaddis's epic novel, On a Frolic of His Own, he starts with the observation that justice is for the afterlife. In this world, we only have law. What then is justice? And what kind of justice do we wish to measure? Equality before the law, or equality without the need for the law to intervene? Compliance with law, even if the law is unjust? Economic or social or religious concept of justice? Procedural justice? To make sure the process of decision-making is fair, impartial, accurate, consistent, and so on? or new applications of economic, social, environmental justice? Questions outpace the answers, and any one answer generates more questions. Questions so daunting that we might easily give up. Without belaboring the obvious, measuring x, the variable of x, depends profoundly on the value assigned to the variable. Plug in justice for x, and we must ask what justice is, what it derives from, how do we see evidence of it or its failure? Is justice a matter of divine command in Plato, or natural rights in Locke, or utility in Mill, or a matter of property distribution within concepts of equality or equity? Is it a matter of consensual social contract measured by maximization of wealth as in Nozick? In criminal law, is it retributive, deterrent, restorative, or even just brutally incapacitating? Or regardless of whether a particular law is good or bad, is justice only a matter of compliance with the law, impartiality, and efficient administration of the cases that arise under it? And as facts may differ and change our sensibilities about the right result, is compliance so simple? As judges exercise judgment that draws on their experience, their social assumptions, their values, can we ever have true impartiality? Can judges be too independent to be just? Think of the judge in Jakarta who once remarked to me that judges should be independent of law itself. And is efficiency only measured by reference to cost and time, and not to the value of what's produced? Is quality only measured in terms of inputs, resources invested in the system, and not outputs, the decisions and their impacts? It's not clear to me that any one feature in any one system necessarily generates the value we seek to realize. Question 3. What is the role of the justice system within the society? What's the context of state and society in which justice operates? I think I've told you the story of the first major phase of judicial reform in Indonesia after Suharto, expressed in the blueprint for judicial reform developed in the early 2000s, failed to answer a central question. What are the optimal characteristics of a judicial decision? What is the product to be produced? Now, this reflected a deeper, unanswered set of questions about what the role of the judiciary in that society should or should not be, whether to resolve simple disputes between neighbors or to resolve the major legal conflicts of institutional authority and power. We know enough to see a conflict of values that complicates this entire exercise. Police states have less crime. Courts with liberal procedural rights have more delay. We have to decide what's important in these trade-offs, what effect we want to produce, among others. These questions vex, because in our constructive ambiguities we hide deeper disagreements. Every country believes in the rule of law, and that is a good thing. But it also has very different things in mind underlying that common belief. And that ambiguity can be destructive too. We can hardly measure justice if we can't recognize the deeper disagreement in response to the larger questions in our qualitative or quantitative measurements. Question 4. How do we compare and measure? Problems don't stop with underlying disagreements, even assuming we could all agree on a value or set of values for what is just, what is quality, what is efficient, what is independent. We still have profound methodological problems of measurement, the why, what, how of our qualitative and quantitative comparisons. When measuring, in any comparative sense, we have to align 3 questions and answers. 1, what is the purpose of our measurement? Why are we measuring? 2nd, what is the evidence, the data we seek to measure in pursuit of that purpose? And what are our methodologies for gathering and the data science or other statistical techniques for quantifying and differentiating those phenomena or data? And third, what is the threshold for differentiating relative positives from the relative negatives? Each of these questions carries its own challenges. And as Einstein once said, we tend to measure only what we can count easily and fail to measure what really counts. Data on social conditions, court administration, survey results, both advance and skew our understanding of what's happening. This raises the issue of comparative methodology. How do we comparatively rate performance? Any measurement of justice is inherently comparative. An unjust result is evaluated only in comparison to a just one. An unjust system or process is contrasted with a less just one. Independence, impartiality, compliant, efficient are all relative terms and necessitate comparative frameworks. They also necessitate the evaluation of smaller features and designs and phenomena and the valuation of their existence or non-existence as important or not important. What are the indicia of judicial independence, for example, in terms of employment, appointment, tenure, removal, salary, and what value between 0 and 1 do we assign to the presence or absence of such features? These are open questions. As I've said, comparison has 3 important elements: the purpose, what motivates it, the content, the evidence to justify it, and the differential thresholds, the line between the existence of a condition and the non-existence of it. This is true on a macro scale, from big ideas of just or unjust to significant characterizations of key attributes of justice, fair, equal, impartial, to the micro evaluation of specific decisions. Measuring justice, therefore, has to contend with these methodological challenges. The values that underlie the characterization, the chosen evidence of justice or injustice, the evidentiary threshold to characterize the phenomena one way or the other. Question 5. How can we make this less daunting? How can we focus on the common, severe, pressing problems facing courts and not allow ourselves to be paralyzed by the methodological difficulties that I've described? Comparing apples and oranges is one thing, comparing fruit salad is another, comparing blended fruit, whether designer juices or smoothies, is a third altogether. And the philosophical and methodological challenges of measuring justice on a multinational or global scale are so vast, so vexing. It may be, as I've said, insurmountable to compare systems or societies in any meaningful way without breaking down the specific problems we wish to focus on into much smaller units of analysis. For example, we could start, as this project does, with the proposition that for systems to be just, judicial independence is a precondition. Political interference and financial corruption of the judiciary can't be tolerated. We might further agree that justice delayed is justice denied in both civil and criminal settings, and also agree that physical and psychological coercion of the accused, including the use of torture, is unjust. In other words, by focusing on specific aspects of justice, independence, efficiency, dignity, accuracy, and other values, and by studying common problems of where legal systems struggle to meet the values at least articulated by the societies they serve, we just might be able to make some progress in measuring justice. Reduction here may be necessary both before and simultaneous with our more systemic assessments. So can we dedicate our rigorous attention to the values, evidence, and thresholds for characterizing judges as sufficiently independent, resilient in repelling corrupt influences, efficient in taking just enough time to resolve cases effectively? This will help, but at the same time, we have to be careful that the rhetorical conventions we use, the ways we express things, not prefigure and bias our views from the outset. For example, we say, justice delayed is justice denied. But how do we know what's a delay? delay itself presumes we've taken too much time. The systems that are quick may be too hasty to make accurate decisions. The systems that are slower may be trying to get it right, or they may have different values that thus require more time. For example, delays in India are in part attributable to horizontal or coordinate ideals of authority and very strong procedural rights and a lower priority placed on managerial expertise and discipline of judges. Judicial independence presumes that a separation and independence from political influences are more likely to preserve impartiality. But we should ask, why is this so? We are concerned justifiably about political interference. We could also equally be concerned about independence as a source of partiality. Independence of mind, taken to an extreme, may actually be a license for explicit or implicit bias. Without accountability, it may actually increase the risk of corruption. It may lead to a vertical interference by senior judges in the impartial judgment of more junior judges. It may help to tackle these problems in specific contexts of contemporary challenges of justice reform, from sociological sources of bias to ideological propensities, in systems where cases may be assigned randomly to reduce overall bias or not. These are tough problems in which to account. Question 6. What can we do about these difficulties within this project? To do this effectively, we have to argue simultaneously for the impracticability and imperative of measuring justice. As I've said, first, arguing impracticability will keep us honest about the limitations of our exercise. Pushing this thesis forces us to be clearer on our conceptions, our evaluations, our methodologies, to see and address the tough questions. Second, committing to the imperative of overcoming this impracticability will motivate us to overcome these limitations. This is where a large army of empiricists with new techniques in data and computer science come into play. This is why Eric and I are collaborating on this project. How can we take measurement seriously with the application of new powerful tools of empirical data collection and quantitative comparison? Eric will outline how empirical techniques have developed over the past 3 decades, pointing out some advances and continual difficulties in the literature, including the judicial independence literature. Based on these observations, we envision how these techniques may advance our understanding and improvement of justice systems. We still need to understand the qualitative value of each and every case, how it is resolved, what impact the resolution has, and so forth. There's no replacement for that. But just as in experimental science, the natural sciences, computation allows us to look at systems for new clues, new hunches, a more empirical understanding for what's going on in the system we're studying and how to fix it. From that systemic analysis, we go back to reductive experimentation with greater clarity and focus, only to repeat that cycle again and again. That's how we advance our scientific understanding in any field. That's how we will do it here. That's how we advance the cures to increase the effectiveness of our approach to improve the systems we have, whether they be human biological systems or legal systems. That's how we measure better and then do better what we measure in judicial independence, in the achievement of justice. And that's why we are honored to collaborate with Shimon and all of you here, both physically present and virtual, on this important 40-year-old project and dedicate ourselves to the next chapter of scholarship and impact. And I want to thank and congratulate all of you in that effort. And since it's December 31st, 2021 here as I record this talk, as we say, next year in Claremont, McKenna, college, next year in Claremont, California, next year in Jerusalem. Cheers, everybody. Have a great conference.
Thank you very much, Professor Hiram Chodosh, who delivered the presentation jointly on behalf of Eric Helland. Both are co-chairs of this conference, together with me, and also co-authors, as I mentioned, of the last volume on the book series on judicial independence. All books, 5 of them, were published by Brill Nijhoff, and this is an opportunity to thank also our publisher, Brill Nijhoff. Thank you, Professor Hiram Chodosh, for in fact setting for us a kind of roadmap for our work in this important project of measuring justice, kind of sort of a menu for us, what we should examine, evaluate, and study. We are looking forward to the second part of this conference, which will take place according to the plan in Claremont, in order to continue the work on the evaluation and laying down the measurements of justice. It is now my privilege to introduce to you and ask Professor James Kelly from the University of Concordia to give his presentation. Professor James Kelly has been for many years the chair of the Committee on Administration of Justice of the International Association of Political Science, and he has been pursuing the study of judges and judicial independence and judicial administrations for many years. And I'm now asking Professor James Kelly to give his presentation. Professor Kelly, please.
Well, hello, I'm Professor James Kelly from Concordia University in Montreal, and my talk is entitled Judicial Independence Without Judicial Impact, the Emerging Challenge of Populist Constitutionalism in Canada. Now, my talk focuses on the Canadian case, but I want to begin with a couple of important statements. I want to be clear that judicial independence is both constitutionally and statutorily protected in Canada. The legal rights provisions of the Canadian Charter refer to judicial independence in Section 11D, and this provision states that any person charged with an offense has the right to be presumed innocent until proven guilty according to law in fair and public hearings by an independent and impartial tribunal. Now, in 1997, the Supreme Court of Canada determined that Section 11D provided both institutional and administrative autonomy to Canadian courts. So statutorily, the independence of the judiciary is protected from political interference by way of independent judicial appointment committees that make recommendations to the federal Minister of Justice on appointments to the bench, and a similar process occurs at the provincial level. Thus, by all measures, appointments, security of tenure until age of 75, institutional autonomy, the Canadian courts demonstrate robust judicial independence. My talk focuses on an emerging paradox in Canada, and that's robust institutional independence combined with declining judicial policy impact in key areas of public policy. Now, this paradox has emerged when the Supreme Court of Canada has invalidated statutes in important areas of public policy, such as medical assistance in dying, safe consumption sites, Quebec and the Charter of the French language, prostitution reform, healthcare policy, and criminal justice reform in Canada. Now, the paradox is really what I mean by the declining judicial impact, which is explained, I think, by 2 developments. And this is how I explain the puzzle. Post-judicial review, by which I mean legislative responses to judicial invalidation of salient areas of public policy. And secondly, and this is the new and I think challenging the populist trend in Canada. And this is the use or the preemptive use of the Charter's override provision as a way to prevent judicial remedy of potential findings of unconstitutionality. So in my presentation, I want to explain both trends: post-judicial amendment and preemptive use of the Charter's override clause. And I'll provide an example of each. And these are contemporary examples within the Canadian Federation. The paradox that I've referred to is really explained by Mark Tushnot's model of strong form judicial review, which in turn has been met by strong form legislative responses in the Canadian Federation, and the two that I referred to: post judicial legislative response and the preemptive use of the notwithstanding clause. Now, I want to be clear, I don't mean that judicial decisions are regularly overturned by Parliament or the provincial legislatures. This is not the case. Instead, I focus on a subset of cases where this occurs, and these are really in important areas of public policy. Now, legislative non-compliance can occur when two variables are present. The parliamentary body required to implement the judicial decision disagrees with the decision, and the decision involves an important area of public policy. Now, legislative reversal is particularly problematic in Canada because despite being a Westminster system of government with parliamentary supremacy as one of our core features, it's always been tempered by federalism before 1982 and after 1982 by a fully judicialized and constitutional Charter of Rights. Now, there are two provisions in the Canadian Charter that speak about strong form judicial review. The first is Section 52, which is the Constitutional Supremacy Clause, and the second is Section 24(1) of the Canadian Charter of Rights and Freedoms, which allows courts to remedy rights violations in any way that the court considers appropriate and just in the circumstances. So in this respect, judicial review is both independent, it's robustly independent in Canada, and Canadian courts have robust remedial powers provided under Section 52 and Section 24(1) of the Canadian Charter. Now, how is strong form review weakened? I'll briefly provide an example of each instance of how strong review can be weakened and the efficiency of judicial review compromised through legislative responses. And the first example that I'm going to use comes from a 2011 Supreme Court of Canada decision, which is known as the Insight decision. Now, in 2011, the Supreme Court of Canada ruled whether or not the Minister of Health's refusal to reissue a license to operate for a safe consumption facility in Vancouver violated the Section 7 or security of person rights of intravenous drug users, so a marginalized population that had relied on this facility for important health services. Now, in the Insight decision, and to provide some context to this, the Harper government had campaigned on a law and order agenda and had actually rejected safe consumption sites as a component of harm reduction. But once in office, it acted consistent with its criminal justice approach and prevented the only time, or at the time, North America's only safe injection facility in Vancouver from operating. And so this refusal to reissue the license led to a Section 7 challenge against ministerial discretion. Now, in its decision, the Supreme Court of Canada was unequivocal that the Minister of Health had, in fact, infringed the Section 7 rights of this vulnerable population, and in a unanimous decision, ordered the Ministry of Health to immediately reissue a temporary license to operate for this facility. Now, the court imposed this remedy because the Chief Justice stated, and I've highlighted in yellow here, that there is nothing to be gained and much to be risked in sending the matter back to the minister for reconsideration. So this is a strong form decision in which the Supreme Court of Canada remedied the unconstitutional use of ministerial discretion. Now, this last point is important. The act was held to be constitutional, but it was ministerial use of decision-making powers authorized by the act that in fact was found to be unconstitutional. More so in the decision, the Supreme Court of Canada outlined 5 conditions or factors that must be used by the Minister of Health when deciding to issue a license for any additional safe consumption facilities. What's interesting is how the government reacted to this very strong judicial rebuke. I think what it does is it demonstrates how a legislative response can limit judicial impact despite the court issuing a strong form decision. What did the government do? First, it decided to create a legislative framework for the constitutional use of ministerial discretion. This, in fact, was unnecessary, as the court took issue with ministerial discretion and not the statutory authorization of ministerial discretion. By doing so, it controlled the legislative agenda and timeframe, and in fact prevented the establishment of any additional facilities during the government's remaining 4 years in office. Secondly, it took the court's 5 conditions and created 57 requirements that must be met by any health organization seeking to establish any additional safe consumption facilities. Third, it placed the onus on local organizations to demonstrate the public health benefits of safe consumption sites, despite the fact that in the 2011 decision, the Supreme Court of Canada argued that the health benefits had clearly been established. The public health outcome, or the public policy outcome of this legislative response, is very clear. Despite a strong form decision, the Harper government never authorized the establishment of a single additional facility. This occurred through legislative delay, taking 4 years to respond to the court, administrative red tape, the 57 conditions, and finally the fact that the Supreme Court of Canada had to rely on a government opposed to the decision to implement its decision. Since its defeat by the Trudeau government in 2015, an additional 38 facilities have been established. And I think what the Harper government and the Trudeau government demonstrates is the conditions under which judicial impact can be advanced, and we've seen that by the Trudeau government, or hindered by the Harper government. I want to now turn to the second legislative strategy, which I'm referring to as preemptive prohibiting of judicial invalidation and remedy. And this is drawn from the province of Quebec, but before I do, I have to introduce this constitutional provision, Section 33 of the Canadian Charter of Rights and Freedoms. Section 33 is the legislative override. It allows Parliament or a provincial legislature to override a judicial decision. Now, during the first 40 years of the Canadian Charter's life, the assumption was that Section 33 would only be invoked after a judicial decision. But that's not, in fact, how the provision is written. This is perhaps one of the structural problems of Section 33. Now, I raise this because of the current debate in Israel, whether to create a legislative override modeled on the Canadian Charter of Rights and Freedoms. Now, as written, it's the only conditions to using the notwithstanding clause that exist is the provisions that it applies to, and it's temporal. It lasts for 5 years. While a preemptive use of the notwithstanding clause is not prohibited by Section 33, perhaps any modeling of Section 33 in Israel should take that into consideration. And I want to provide one example of the preemptive use of Section 33 and how it can significantly undermine not judicial independence, but judicial impact via policy decisions. And this involves Bill 21, which was introduced in 2019. It's known as the laïcité policy, or state religious neutrality. The bill, as we can see, prohibits the wearing of religious symbols by either public servants, broadly defined, or citizens seeking public service. Now, this bill has extensive reach, largely because the definition of state employee is rather large. It's really any public publicly funded institution, from daycare workers, teachers, police, judges, civil servants, etc. Now, Bill 21 clearly engages several rights protected by the Canadian Charter of Rights and Freedoms: freedom of religion, freedom of conscience, mobility rights, and gender equality. Given that Quebec has a significant Jewish, Muslim, and Sikh populations concentrated within the island of Montreal, this law has a disproportionate effect on religious minorities. Moreover, the very religious minorities that are likely to wear religious symbols in the public sphere. As a result of Bill 21, targeted religious minorities that wear religious symbols are ineligible for state employment. And again, this extends to any institution that is publicly funded. And moreover, citizens may be denied public services if they refuse to remove their religious symbols, particularly face coverings, when interacting with state officials. If subjected to judicial review, this bill would surely be declared unconstitutional under Section 52 of the Canadian Charter of Rights and Freedoms. Moreover, it would be subjected to judicial remedy under Section 24(1). However, none of this is going to happen. Anticipating a negative judicial ruling, the Quebec government decided to preemptively invoke the notwithstanding clause in Section 34 of the bill, as I've highlighted on the PowerPoint here. While preemptively invoking Section 33 does not prevent judicial review, it prevents judicial amendment and remedy of an unconstitutional law. So why is this significant? Well, I think this is what we're starting to see in Canada, a growing trend, the preemptive use of the notwithstanding clause. As to date, in addition to Quebec, both the provinces of Ontario and New Brunswick have used Section 33 in a preemptive way. Now, given the rise of populist constitutionalism in Canada and abroad, the challenge, I think, for judicial efficiency in the coming years will be the emergence of this populist constitutionalism that challenges the role of the courts and the impact of courts in established constitutional democracies. Now, returning to the Israeli case, while I support the use of the legislative override to correct judicial overreach, I think it should only be used after a judicial declaration and not to prevent a judicial declaration of unconstitutionality. Thus, if Canada is to be the model for Israel, I would suggest that you ensure that any legislative override clause specifies that it can only be used in response to a judicial decision and not to preempt judicial declaration of unconstitutionality. So in closing, the purpose of my talk has been to show how robust judicial independence can be compromised by legislative responses in salient areas of public policy. The concept of courts as implementer dependent institutions that rely largely on parliamentary actors that may oppose their decisions to implement their decisions. And secondly, the danger that populist constitutionalism and preemptive uses of legislative overrides present to courts in advanced constitutional democracies such as Canada. So given that we appear to be entering a new phase, that of populist constitutionalism, the example of Quebec and Bill 21 is a cautionary tale. Well, thank you very much for listening to my talk, though it is done virtually through Zoom, and I look forward to the rest of the conference. Thank you very much.
Many thanks, Professor Kelly, for your very interesting, for the Israeli audience, presentation. In Israel, there is a widespread assumption that the overriding power has not been invoked. And your presentation, of course, shows not only that it has been invoked, but it is now invoked preemptively, not only post-judgment. So it is important for our audience in Israel to take this into account. We still debate and deliberate in Israel which model of override will be introduced in Israel. and the discussion is really focused on the size of the majority that the parliament will have to approve the override, whether it is simple majority, 61 out of 120, we only have 120 MPs, or more, and that would mean either 65 or 70, and the discussion goes on about the level, the size of the majority which is required. So thank you very much, Professor Kelly, for your interesting presentation. We look forward for the full paper to be, I hope, to be published in our next volume or in the book series of Judicial Independence. And now it is my pleasure to invite Judge Michal Agmon Gonen to speak on the judicial independence and appellate review. I want to mention that for me, Judge Agmon Gonen is, in fact, the advocate of internal judicial independence in Israel, and has written on the subject and really demonstrates how important it is to focus both from the theoretical point of view as well as from the practical point of view, the importance of the internal independence of the judge in the judicial system. Judge Agmon Gonen, please.
Thank you very much. Hi, everyone that's watching us over the Zoom and the people who are present here. Thank you, Professor Shetreet. I'm really glad to be here. I'm a presiding judge, so I'm talking both from the view from the court as well as the theoretical view, because I do read and write on the subject, which I think is very important. The modern conception of judicial independence is not confined to the independence of an individual judge and to his or her personal and substantive independence. It must include the collective independence of the judiciary as an institution, as the speakers before me had emphasized. Likewise, judicial independence should not be perceived only in terms of shielding the judge from executive pressures or legislative interference. It must also encompass internal independence, namely the independence of the judge from his or her judicial colleagues or superiors. Most studies of judicial independence focus on the judiciary's independence from the other branches of government or individuals. The concept of internal judicial independence is intended to protect judges from undue pressure from within the judiciary. The internal judicial independence requires the judges be free from instructions or pressures from the fellow judges and vis-a-vis their judicial superiors. In this regard, most studies discuss the pressures from the judiciary administration. Internal judicial independence is an umbrella term covering several categories of activity within the judicial role and judicial branch organization: decisional, personal, procedural, and administrative. Today, I would like to address judicial independence from the appellate review perspective. Within the entire judicial branch, an issue of independence may arise when analyzing the relationship between higher courts and lower courts, judicial independence and appellate review. The internal independence can be jeopardized by a hierarchical organization of the judiciary. In such a system, the decisions taken by a given judge are subject to the control of the president of the court over subordinated judges, and more in general, through preliminary instruction and directive or subsequent checks by higher judges, be they appeal or Supreme Court judges. It is necessary that the individual judge hold a sufficiently autonomous position within the judiciary. With regard to the variable of formal and informal pressure, it is worth examining the obvious fact that no inferior judge, I'll call them this, in a judicial hierarchy is totally independent of the reality of appellate review and reversal. To refer to a lower court judge as independent merely state that they are formally subject only to the superiors in a judicial hierarchy as set in the law, rather than to extrajudicial authorities. Independence emphasizes institutional autonomy, not any claim to similar autonomy by actors within the institutional structure. There are a wide variety of ways in which a higher appellate court may influence a lower court decision. The first one is the influence high court or appellate court judges has on the promotion process to higher courts. Because of the short time I have, I will not elaborate on the subject, but it might be interesting to measure if the amount of reversal a judge has as such is affecting his or her promotion. This might be measured against the average reversal rate and the possibility to appeal certain type of cases. Higher courts may also influence lower court in their choice of which cases to review. For example, in the United States, the Supreme Court discretion over granting certiorari allows it to choose which lower court cases and which issues to review. These choices, in turn, send signal to lower courts about what behavior will warrant review and possible reversal, and what behavior will not. Cameron, Singal, and Songer, in two articles from around 20 years ago, from 1994 and 2000, found that a conservative higher court is more likely to review liberal decision of lower courts than conservative lower courts' decision. They showed that a conservative majority on the United States Supreme Court has tended to grant review and reverse a larger portion of the reputedly liberal Ninth Circuit decisions. In countries like Israel, where most appeals are by right and not discretionary, one could think that this problem does not arise. But it might be interesting to check if conservative appellate court judges, if we know which one is which, reverse more liberal court decisions and vice versa. What if a judgment is reversed, but the higher court has a minority judgment approving the case? This is also something that might be interesting to look into. I'm posing more questions than answers, but in this point, I think there is a little research on measuring those questions. Another way higher court judge can influence lower court judge is the amount of discretion in intervening in lower court decision. The more the higher court intervenes, the less independent the lower court judges are. In this regard, I would like to talk about a possible intervention in lower court judge discretion in a way that might challenge judicial independence. Appellate court overruling lower court judge on a certain point, but returning the case to the same judge to continue with the case. It is one thing for a judge's discretion to be overturned on appeal. The risk of that happening is an incident of judicial life that every judge accepts. Higher court rulings are part of the law and thus not considered a problem of judicial independence. But what, for example, if a lower court judge acquitted someone on a non-jury case or ruled in favor of one party? On appeal, the appellate courts find that some evidence the lower court ruled out should be admitted. The higher court does not rule what should be the outcome of including this evidence, but returns the case to the lower court judge to take it from there. Can she truly independently reach a different outcome? What if as a result of what I just described, a motion to recuse the judge is filed, claiming she's not impartial anymore after stating what she thinks about the case. Should she recuse herself after the higher court returned the case to her with instruction to follow? Recusal is demanded in any proceeding in which the judge's impartiality might reasonably be questioned. Isn't that the case when the same judge is supposed to continue sitting on a case after being overruled, even in part? It might be interesting to consider the possibilities higher court have in a case of appeal. No doubt the higher court can reverse or approve a decision. As I said, this is an important part of the rule of law and the right to be heard in court. But if the higher court can refer the case back to the lower court, this might cause a judicial independence issue. The question here, of course, is one of efficiency. Again, we talked about it a lot today. It will take far more time for a new judge to hear the case from the beginning or from that point, if that is possible. But judicial independence from within questions relate to the tension between efficiency and independence, and this is a question I think is really worth exploring. Another side or another phenomena that connected to this question is whether appellate court can or should remove trial judges from hearing certain cases because of previous decision on a certain matter. This is the opposite picture. For example, there was a dispute in Oklahoma over death penalty by lethal injection. The Arkansas courts has been embroiled in an internal dispute regarding this. In April 2017, not so long ago, Judge Wendell Griffin participated in a public event opposing the death penalty and then issued a temporary restraining order as a judge against a pending execution. The Supreme Court of Arkansas reversed that order, but added that this specific judge be barred from hearing death penalty cases at all from that point on, and referred the situation to the State Judicial Conduct Commission. The commission said that the Supreme Court of Arkansas could not issue such a decision because it was a disciplinary junction that had special proceeding due if such a decision should be made. The judge has to defend himself. And I think this is very important because sometimes judges are being assigned either by the president of the court or by not a proper decision of the appellate court, but hints by the appellate court that it might be better if a specific judge should not be sitting on certain cases. And I think it's very dangerous because unless there is, of course, if the appellate court rules in a certain case that this temporary restraining order wasn't in line, that's fine. But and if it's mandatory to, after this ruling, to rule the same, that's okay also. But to bar someone from a certain subject only because of previous ruling, I think this is an issue of judicial independence from within. I'm currently on the bench both as a higher court judge and a lower court judge. As a district court judge in Israel, the district court is an appellate court over the magistrate court on some subject, and its decisions are subject to appeal by right to the Supreme Court on other matters. As such, I try to present real issues that come up, issues we cope with as appellate court judges and as inferior court judges, And I think a more thorough research and recent research into those questions will be very interesting. So I challenge all the people here who write about this subject to take those matters also into account. Thank you so much.
Many thanks, Judge Gonen Agmon, for your thought-provoking and insightful presentation, both from the angles and aspects of theoretical analysis as well as from the practical point of view. And it is now my turn to present my short presentation on the subject of the indicators of the justice system. And I will focus on overview of the issue plus the indicators of the justice system in the Mount Scopus standards. So the topic is indicators of justice and the rule of law under the Mount Scopus International Standards of Judicial Independence. Let me begin by mentioning the fundamental values of the administration of justice. One is, of course, not necessarily in the order of priority, independence and impartiality of the judiciary. Second is fairness and justice, or procedural justice. And that means that it is fairness relating to the substance, and procedure relates to how the decision is made, the rules of evidence, the rule of hearing, and so on. Third value is efficiency, of course. 4 is the public confidence in the courts. Menachem Hoffnung will be giving tomorrow a presentation on his study on public confidence in Israel. Accessibility, or the access to the judicial system, which means geographical access, spreading the courts to allow access from the geographical point of view. It means also substantive, it means procedural, and it also means supporting legal aid for those who cannot pay the cost of the professional service or the cost of the fees. Another important value is transparency, or the principle of public or open court. And of course, accountability has to be put also on the agenda when we decide to evaluate the fundamental values. And finally, the constitutional protection, the constitutionality, which is important, that the level of protection of judicial independence in regulating the conditions of service has to be in the normative level of constitutional provisions rather than legislative provisions. We have talked quite a lot already about the realities of court delays and caseload crisis and that is facing the courts. And I would like to mention one case in which the Supreme Court of Israel has to face the issue between efficiency versus justice, or efficiency versus ensuring justice. And that case involved a request by a newspaper in Israel to disclose the names of the judges who are delivering the judgment for a certain number of years. And the question that the court had to deal with is how to balance between efficiency on the one hand and justice and judicial independence. And here is what Justice Hayut, the chair, said, the president. The concern towards the functionality of the judicial branch that my colleague Justice Arbel raised in her opinion, as well as my brethren Handel and Rubinstein, in their opinion, are very disturbing and merit decision. It is especially disturbing to me the concern that the emphasis of the efficiency of the judicial branch in the publication of cases pending before individual judges may breathe down the necks of the judges and may push them to accelerate the hearings and the judgment at the expense of their quality. After all, judges are not a production line for verdicts. My colleague noted this and stated the judge cannot exercise his duty qualitatively and to its fullest when on one hand, he holds a hammer and on the other a stopwatch. Indeed, it is important to remember the efficiency is not everything, and such evaluating the activity of the judicial branch based on production and productivity may distance the judicial discourse from its essence, which is to hear which is the heart of this practice, that is doing justice. Regarding these are words written by the scholar I'm quoting modestly, by the scholar Professor Shimon Shetreet more than 30 years ago, which still hold true today, since the purpose of the judicial process and the justice system is making justice. We must take care to not examine it by production and productivity and to apply to it haphazardly terms of efficiency from different areas of management. So I think if we refer to the presentations yesterday in the opening session and the presentations of this morning, I think it is accepted that one must make sure that we balance very carefully between the fundamental values of the justice system. Now, indicators of justice have been developed by many organizations, including the EU Scoreboard Justice, which we heard analysis this morning from Professor Paul Nemitz in detail. There are also the indicators of the European Commission for the Efficiency of Justice, and there is also the Human Development Index. The World Economic Forum also publishes from time to time important studies on it. The World Bank also, and the World Justice Project Open Index. So I'm just mentioning it just to put it on the table, that we are sharing with many other organizations the important burden of developing indicators for the justice system. I will not detail all these organizations, and I want to go ahead and present to you the text of the amendments which we adopted in London in 2018, and we decided to put as guidelines for the international community, guidelines for the scholar, what are the main indicators from our point of view that has to be judged for the purpose of indicators of democracy and the rule of law. And so I'm just showing you what we selected as indicators for this subject: legality, supremacy of the law, compliance with the law, and making sure the relationship between international law and domestic law, legal certainty. Of course, legal certainty and justice, of course, are always to be balanced. We have in common law the principle of precedent, but on the other hand, we want to adapt the law to changing conditions, prevention of abuse of powers, equality before the law, and independence and impartiality of the justice system, of course, which is the subject of our conference. And this includes independence of the judiciary, of the individual judge, of the judiciary as a whole, of the prosecution service, autonomy of the judiciary in administrative matters, in budget matters, and independence and impartiality of the bar, the legal profession. Of course, fair trial and procedural justice is another element of democracy, and constitutional and administrative judicial review, the availability of both constitutional review of statutes and administrative judicial review of decisions of the executive branch are central to the values of democracy. Substantive rule of law, democracy, and respect of democratic minority groups, maintaining and respect of effective opposition in parliament and in the streets are also, of course, central elements for democracy. Protection of the freedom of press and all forms of electronic and digital and social media, and limited government control on private and public media institutions. Of course, there is on the table the issue, do, so to speak, non-human participants in the social media, like bots or robots, do they have right of free press or freedom of expression? Do we grant the freedom of expression only to natural persons, or should we also allocate or give and bestow this right of freedom? So each of these indicator raises many questions, but here we're only putting it on the table as an indicator of democracy. Protection of activities of civil society groups and non-government organizations is very important. We know in the last decades, civil society groups play a very important role in moving and encouraging and changing, whether by going to court and introducing legal change by the use of the courts, or whether by demonstration affecting the public agenda, or whether by effective lobbying by the civil society organizations. So we thought that this is very important to emphasize. Maintenance of principle of civilian supremacy of military and security authorities. So national security is very important, but it has to be subjected to oversight and supervision of the elected authorities, the political elected branches of government. Respect of separation of powers, of course, as a central doctrine. Later this evening, I would make some comments about the fact that the complete development of the theory of separation of powers in England took place only in the year of 2005. Why? until 2005, the Judicial Committee of the House of Lords, which is the House of Lords, the highest judicial authority and the court of last resort in England, was part of the House of Lords, the upper house of Parliament. And it was separated only in 2005. This is one. Second, the Lord Chancellor, for almost thousands of years, held three hats. One is he was Speaker of the House of Lords. Two, he was the head of the judiciary, actually chairing court in dealing with appeals from lower courts. And he was also a member of the cabinet. So we really united the three functions, legislative, executive, and judicial. And therefore, only in 2005, when he was, in fact, separated, remained only executive, and other functions of the judicial nature were switched to the Lord Chief Justice in England. So even when we talk about separation of power, Montesquieu was not aware or didn't make sufficient attention to this aspect when he wrote the Spirit of the Law and published it in 1748. And finally, respect for human rights and civil rights and economic and social rights as part of democracy. Final point. Of course, we see the importance of judicial independence internally in the domestic countries in terms of rule of law, right of the citizen, fair trial, access to courts, etc. But it is important to note that it is also important in terms of enforcement and recognition of foreign judgments and arbitral awards. I will only make a short statement about this, but the principle is that in order for a decision to be recognized in another country, you have to judge it according to two elements. One, independence, and two, integrity. If the judgment does not pass these two tests of independence and integrity, it will not be enforced in another country. This is, in fact, the rule of law, the jurisprudence that is in England in a number of cases. And in a number of cases, it was judged that, in fact, it is the duty of the court to examine that the judge was given by a court, the judgment was given by a court that enjoys independence and that the members of the court have integrity. So you see here the case of Yocus and the other case of Merchant International. In those two cases, the issue is raised and decided, and the court says that it is the duty of the court to review, even if it is recognized by another country. The court, when it comes to its decision, will have to review it by themselves. So, to conclude, the importance to balance between an efficient justice system and judicial independence. It is essential to maintain the fundamental values of justice in the conflict between efficiency and fairness. My view is that fairness should prevail. The importance of judicial independence and impartiality and fairness is important not only within the domestic jurisdictions, but also when it is required to be enforced of that judgment in another jurisdiction. adopting an appropriate model of responsibility of court administration according to local traditions and system of government. Beware of managerial unrestrained powers in court management that may affect judicial independence. Essential foundation to ensure efficiency, develop database and collect data on justice systems similar to the European EU Justice Scoreboard and other reports that establish indicators of justice. And thank you very much for your attention. And now we have a few minutes for you to put questions or make comments from those present. So thank you very much.